Welcome to Bankruptcy Bailout. In this video, we're going to answer the question, what bad things you shouldn't do before filing bankruptcy. So stay tuned, Bankruptcy Bailout buddies. Welcome, borrowers and debtors, to Bankruptcy Bailout. My name is Matt Burkus, Colorado bankruptcy and debt relief attorney. And today we're going to discuss some things you should not do before filing bankruptcy, because those things are going to make your situation worse, not better. Now, I get it. When people are struggling with debt and they start considering bankruptcy, their mind starts to go crazy. It's very similar to a fight or flight syndrome. Now, in modern times, we're not being chased by lions on the savannah, but our financial lives are our means of survival. And when that gets threatened, it's the same psychology. So you start to immediately worry. Are you going to lose your house? Are you going to lose your car? Where are you going to live? Are you going to be able to work? Will you be able to get a job? Will you be able to keep your job? Will you be able to get credit? And all these worries start to happen. Now, we can do a whole hour-long video on debunking those worries, but that's not what we're going to do today. The point of this video is to say, for you to maintain the status quo and really don't make any changes to your situation before filing bankruptcy, or better, before talking to a bankruptcy attorney who can listen and gather the information needed to determine what is the best course of action. Because a lot of people, when they start worrying about stuff, they're going to start taking actions that make things worse. And the two broad categories of actions that make things worse are what we call a preference, and I'll define that here in a moment, and asset transfers, where they put people on title, or they give things away in hopes of trying to keep them hidden from the bankruptcy, and that's bad. All right, so the first category is a preference, and a preference is where you pay a creditor some amount of money to either keep them out of the bankruptcy or to keep them satisfied. And the two common scenarios here are, one is you owe a friend or family member. So let's say, grandma lent you $2,000, to pay rent that month. And you're like, well, I want to pay her back before the bankruptcy. Don't do that, because the bankruptcy can go unwind and get that $2,000 from grandma, because she's technically a creditor of yours, no different than Chase or American Express or US Bank or any other credit card. All right, she's what we call a similarly situated creditor, and you can't prefer one creditor over another as you're going into bankruptcy. And the other scenario where this question gets asked is, well, the debtor wants to keep a credit card so they can rebuild credit after bankruptcy. So they're like, hey, can I pay my Chase credit card where I owe $1,000 before the bankruptcy to keep them out of the bankruptcy? And the answer is, no, you can't do that. One, it's a preference, and the trustee is going to go get that $1,000 from Chase. And two, Chase is going to close the account anyway, whether they have a zero balance and whether you list them or not, because all major creditors subscribe to services that let them know when one of their customers files bankruptcy. So Chase is going to find out about the bankruptcy anyway and close your account. So don't waste the $1,000 to pay them off. Just include the debt in the bankruptcy and discharge it. All right. So the first one there is preferences. Do not pay back any creditors ahead of your bankruptcy without talking to a bankruptcy attorney. And we can do a more in-depth video about preferences and what you can and can't pay. But just for this video, it's don't pay back any creditors ahead of the bankruptcy, and go talk to a bankruptcy attorney to find out what you can do. All right. The next one is the bigger problem of the what you shouldn't do, and this is transferring assets out of your name. That doesn't work ahead of a bankruptcy. And some of the bigger ones, some of the bigger problems is when people start putting their kids on their real estate. So maybe I have an older couple or a retired couple who are getting ready to file bankruptcy, and before they speak to me, they put their son on title to their house so that it can pass to him in the event that he dies. Now, that's not a very good estate planning method, all right? So in general, you should speak to an estate planning attorney to figure out how to transfer the house without putting him on title ahead of time. But if you put someone on title to your house or to your car in hopes to protect it from bankruptcy, you're going to lose the protection, and the trustee is going to be able to take that asset. Because by putting someone on title, odds are, I'm guessing, or why this is a problem, is they didn't pay you the value of what they got, right? So if you have $100,000 equity in your house, and it's husband, wife, and then they put their son on title, where the son just got a gift of $33,300 of equity and didn't pay for it. That's a fraudulent transfer in the bankruptcy scenario. Okay? And the bankruptcy trustee can go back 2, 4, and sometimes 10 years to unwind that gift. All right? So don't be doing that. And it's the same issue with cars. Don't just, give your car to your daughter to keep it out of your bankruptcy, because the trustee is going to ask, have you transferred or sold any assets in the last 2 years? And you're either going to perjure yourself, which is criminal, or they're going to unwind that transaction. And this goes for all sorts of little assets too. The other place where we see this, especially in Colorado, is with firearms, because there's no bankruptcy protection or asset protection for firearms in a bankruptcy scenario. So if someone's got a particularly valuable arsenal, they'll often say, well, I gave it to my friend. And the trustee's like, well, let me see the money they paid for it. Yeah, that's what happens. And then you create all kinds of problems in the bankruptcy with fraudulent transfer. So those are some of the things you shouldn't do ahead of your bankruptcy. So again, don't pay back any creditors ahead of the bankruptcy until you speak to a bankruptcy attorney to find out what, if any, benefit you can get from that. And then maintain the status quo on your asset ownership. Do not be transferring assets to siblings or to children or anything like that ahead of a bankruptcy, because the bankruptcy courts can unwind those transfers and then get at those assets. And that can create a really bad thing. And I've seen people, not my clients, but I've seen people lose their houses over a situation where they put their son on title, or they put their kids on title to their house, 6 months or a year ahead of the bankruptcy. And the trustee was able to unwind that transfer. And because of the transfer, the homestead exemption doesn't apply anymore, and they just sell the house out from underneath the debtors. So that's bad, as you might imagine. So my name is Matt Burkus. This is Bankruptcy Bailout. I offer free initial phone consultations to the residents of Colorado for the purposes of bankruptcy, and we look forward to working with you. Take care.